scene of a crime, an incident, or an accident might qualify you as a witness in the matter. As to whether you are fit to be a witness, it's a matter of law. Today on Law Express, we discuss witnesses. This is Law Express. Don't go away. We'll go for a quick commercial break. When we come back, we delve into the topic witnesses. My name is Nwela Seidu.
Iris K. Agri-Orleans is a private legal practitioner, and she likes reading and sightseeing. Tony Nyaku is a private legal practitioner and law lecturer at both Wisconsin University College and Greenfield College. Aside his legal work, he enjoys researching and listening to music.
Nwela Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
So a witness is a person that serves as a source of evidence in legal proceedings, and a witness offers first-hand information that either supports the claim of a party or refutes the claim of the other party. By law, everyone is competent to be a witness. Even children are competent witnesses, and even persons with mental disability are competent witnesses. Yeah. However, to determine whether that person is competent to be a witness, you must be able to show that the person understands the duty to speak the truth, and that the person also is able to express him or herself coherently to the court, so that whatever piece of evidence he is proffering will be understood. That would mean that it doesn't matter if a person is illiterate, yeah, or a person cannot speak the official language, which is English. As long as you can speak coherently and be understood, you are competent to be a witness. So what will happen in the case of a person who doesn't speak English will be that the court will get an interpreter. That interpreter would necessarily understand the language which the person who cannot speak English is speaking and understand English, and will be the source of interpretation between the court and the person who is speaking the language.
If you look at evidence, which is a very crucial aspect of your journey throughout the court, even before you go to the court as a litigant, you need to know what you're going to put before the court to establish your claim and how you're going to do that.
The name of the game is evidence.
Evidence, and that is where witness comes in. You determine that, okay, am I going to do that through affidavit evidence? Am I going to put everything through a witness, and as a
witness statement first.
Witness statements, yeah, and all that. And so you need to know at what point are you adducing a particular evidence to buttress your point. And so before you go to court, you need to gather your evidence,
your
information that you need to establish your case before the court. And in doing that, you put in your witness statement, you attach your document and all that, and at trial you put in your witness before the court. And so the witness testifies on whatever has been placed before the court, and this witness prefers to have personal knowledge about whatever it is that the person is coming to testify. According to the law, before you testify, you need to have personal knowledge about what it is that you want to testify about. So you go in there, you give testimonies about your personal knowledge, as counsel mentioned. the various type of evidences and all that. You can just be an ordinary witness or an expert witness. Be as it may, if you're an expert witness, you are required to testify on particular stuff that you have personal knowledge on. And if you're also testifying on behalf of a party, not as a expert witness, you're also required to testify on matters that have come within your personal knowledge.
We need to break down what an expert witness is for the benefit of our viewers. And these are usually professionals or people with some expertise in the given area. And they could be called by the parties or the courts on its own to come and attest to matters that are niche or that they possess superior knowledge over, to assist the courts. And although this evidence is normally solicited from these people, the court, okay, when I say the court, I mean the judge, is not bound by whatever this witness brings. It's just something that he might consider or she might consider or leave out based on the value in adjudicating the matter.
Yes. So the difference between an expert witness and a lay witness will be that a lay witness will simply have first-hand information of the matters that occurred, where all you'll be telling the court is what has happened, and not necessarily your opinion, even though you may give an opinion based on the general premise of what has happened. With regard to an expert witness, because of that specialized training that you may have,
and that is the reason.
And
for
that
which
is
they
the
were
reason
called.
why they have brought you in.
Yeah.
So they are two different. They serve two different purposes. So an expert witness may not have first-hand information of the exact matter that went on. What the expert witness will be seeking to tell the court is why, in his or her expertise, something occurs or something is expected to occur. So those are the two differences. Another thing that, as we are going through this, if we have to understand what a witness will do when you come to court at first.
Yeah.
You would usually swear an oath. You
Before
take an
then,
oath.
we should talk about how they even come to court.
Yes.
You could be subpoenaed,
You,
or you could be invited by
Invited.
one of the parties or the court.
yes.
So probably we could explore that more.
Well, so for, the burden is on a party who goes to court and makes a positive averment to lead credible evidence or uncontroverted evidence to establish your case. And the burden is such that you put your information before the court. The court is an independent umpire. The court does not descend into the arena of conflict and then act as octopus looking for evidence for parties. So as a party, your primary duty is to put your evidence before the court. If it is in criminal cases, the proof or the burden of proof is beyond reasonable doubt. If it is in civil case, you only have to show that your case is more probable than it is not. And so in doing that, you have the primary duty of inviting witnesses. I mean, it goes back to the earlier submissions that you need to have personal knowledge so that you don't put somebody who would come and, as it is, say something which is not in line with your claims before the court. Lawyers are ready to jump on that. The moment you say one thing which is not in tune or in line with whatever you have placed before the court, quickly, they make a huge capital out of it. They make a storm out of the teacup. So the primary duty of a court user or a litigant is to place your witnesses before the court. Beyond that also, the court can, on its own motion, subpoena or invite a witness if it thinks that the presence of the
Or
witness
based on one of the parties'
party's application. Yes, I was going to come there.
Okay.
If it is the case that the presence of the person
Is
will
necessary.
aid the court in the effective and complete determination of the matters in controversy, then you would be subpoenaed. Now, it goes to also answer the question, can a person be compelled to come and give evidence in court? Well, the position of the law is that you cannot compel a person to come and testify in court, as in the court cannot compel. We saw that in the election petition where, people felt that the EC herself would mount a witness box to testify. The court said, wait, look, you cannot compel a party to come and testify in court, right? Assuming the court compels you or subpoena you to come and testify, well, disobeying the court orders, you can be cited for contempt. But once you answer the court and you appear before the court, can the court force you to give information? What if you decide to keep silence or to keep mute about it? So that goes to the compellability of a witness, the fact that you cannot compel a party or a person to testify in a matter. So there's a thin line between the court subpoenaing a person, right? Once you are subpoenaed by a court, obviously, if you fail to attend, it goes to contempt, but you can go. But I don't think that, the court can subpoena you to come and testify or force you to testify in a matter. Be as it may, the primary duty is on you, the party, to adduce evidence through your own witnesses for an independent umpire like a court to make determination based on the piece of evidence you have placed before the court.
You would realize that usually subpoenaed witnesses are officers, officials, persons who have done official duties. So what happens is that you subpoena them because they cannot on their own volition come and give evidence to prove your claim. So, for example, a bank official, an official from Lands Commission or State Housing, wherever. So those are peculiar persons that you can subpoena. In the case of a party, the reason why a court will not usually compel a party to come and testify or be a witness in its own case is that the party has decided how they are presenting evidence. They know that they have privilege against a duty,
they also have a duty
and
to
they have a duty to prove your case. They have a duty to punch holes in your case, and they know the effect of whatever piece of evidence that they would bring. So to force a party to testify would be injurious to that party. So it is usually, the subpoena usually works for official persons who have acted in official capacities, etc.
Not the party per se, but also other people around who know the facts,
Who know.
but are just unwilling to
Exactly.
testify through the normal channels of coming in to support a side, filing a witness statement, and all of that. I mean, if that is the only way that the very crucial information they have can be used to assist the court in arriving at a decision, then so be it.
Yes. The danger of doing that as well is that whilst you may subpoena a person who just had first-hand knowledge of the facts but was not willing to come and testify on your behalf, is that you may have an adverse witness where that person will come and clearly the interests of that person is not in line with your interest. And so the evidence you are eliciting counts probably as cross-examination because clearly the person does not want to give evidence on your behalf.
But
so
I mean, it still would give you something.
You will
Which
still
probably
elicit.
will be better than nothing.
It will be better than nothing.
It's
So
just
you
that
have to
struggle
weigh
a little.
Exactly. So you have to weigh your options very clearly
And the
and
risk.
see and the risks associated with that, because you have to know what piece of evidence you are seeking to elicit and what it will do or how it will weigh on the mind of the tribunal.
So the test is how vital is this piece of information?
How necessary it is.
To warrant this.
Exactly.
And then secondly, probably you should look at what are the person's reasons. If the person is just scared of talking in public or scared of a court space or doesn't want to step on toes but is willing to be truthful and understands the duty of telling the truth, then that would be a great candidate to subpoena.
That would be a great candidate to subpoena, because sometimes when you invite a person, it appears as if the person has taken one side,
Yeah.
even though that person may have a relationship with both parties. So, for example, in a company a matter where, for example, a company secretary who acts for the company,
Yeah.
and the shareholders are at loggerheads, you'll see that one may have to subpoena that
Especially
secretary.
where it's all family members.
Exactly. So these are some of the reasons why you may have to subpoena.
The conversation is really exciting, but it's time for a quick break. Stay tuned, viewers. We'll be right back.
Once you come to court as a witness, you will be required to either take an oath or to affirm. You take an oath if you believe in a deity. So you would either swear on the Bible, the cross, or the Quran, or whatever holy book that you believe
Do
in.
they use a rosary?
The cross. They usually use the cross. If you are atheist or you don't believe in anything, you just raise your right hand and you affirm. The affirmation just goes to say that you affirm that you will be truthful in the evidence that you are about to give to the court.
So whereas the religious folk rely on their belief to inspire some confidence in their testimony, you are
Yes.
just saying, this is me, this is my word, and
Yes.
my word is my bond.
Yes. So it's on your conscience as a human being to speak the truth and understand the effects of not speaking the truth,
Yes.
being that you'll be perjuring yourself if you do not speak the truth. Once you have taken that oath, you'll be led in your examination in chief. If your lawyer has filed a witness statement, you would go through the witness
I
statement.
think you are becoming too technical.
Yes. So
I see her struggling to break it down.
In recent times, we don't give oral evidence of how you got to know the first-hand information that we have already spoken of.
Okay, let me help
We
you.
usually write it down.
So before, when you finish swearing, they'll put you in a box. Then the side you are speaking to, speaking for,
exactly.
the lawyer for that side will ask you, so where do you live? What's your name?
And
what do you
try
do?
to elicit the information, that
Yes.
first-hand information orally.
Perfect.
Now we do that in witness statements. So your evidence in chief is contained in the witness statement. So once you are sworn in and you put your witness statement in as your evidence in chief, you affirm that you indeed want to rely on that witness statement, you will go straight to cross-examination.
So before then, so once again, what she's saying in plain terms. You know, I was explaining to somebody that it takes years to train as a lawyer,
Yes.
many years. And you are taught to think in a particular way, to use
Yes.
your legalese.
Yes.
And then you get to certain circumstances where you're required to come back to your pre-law time.
Yeah.
And it's almost impossible most
It's
times because
almost impossible.
you had to go through this training through blood and sweat. But what it simply means is, before, what you would have said in the box, all that about where you live, what you do, what you know about the story, is now reduced into writing. And that is what she calls a witness statement. So you are the witness, and this is your statement or your story, what you want to tell the court about the matter and in support of whichever side you came for. So once that is done and the
Once
judge
that's-
admits it as your evidence in chief, then yes.
I think
So-
it is just before you come in, it is also important to state why we got to, filing of witness statements.
Oh.
Out there, people have this notion, and most often than not, it is the reality that a lot of cases travel a long period in the courts, and some of the delays as it is attributed to the fact that once you mount the boss, you're taken through your evidence in chief, where do you live, what's your name, given an account and all that. Previously, it can take about 3-4 days even to complete
to finish your story.
And so
and that will have to be recorded
exactly
and provided to the other side to prepare to cross-examine, right?
And until recently, the judges would have to handscribe it.
And the lawyers as well. As you go along.
You have to have a backup, who taking notes for you. But I mean, fortunately, these days we have IT, the recorders and all that you see. So to avoid these unnecessary delays of cases in our court, we now have the witness statement where you write everything you know about the matter. In fact, the relevant stuff you know about the matter.
And your lawyers will help you.
Exactly. So, I mean, within some few minutes, you're done, and we move to cross-examination.
Parties, the other sides, would have the benefit of this document way before the trial. So they are ready to cross-examine.
Ready to cross-examine. And this brings us to whether you can be a witness if you are not available for cross-examination.
Okay.
In order that you can be a witness, you must be available for cross-examination. Cross-examination is simply that the lawyer or the other party will have a chance to ask you questions about the evidence you have given. And those questions will be seeking to get more information, get you to admit certain facts, or possibly punch holes in your story or whatever. You would realize that sometimes in court, when lawyers are asking very innocent questions, because parties believe that every question is geared towards
something, an
end. They start being edgy and evasive. It doesn't work. It doesn't really work well, because whilst you are answering the question, you must also realize that as a witness, the judge is observing your demeanor. The judge is observing how you are answering the question. Are you being evasive? Are you consistent in what case you have brought to the court, etc.?
I think you have laid a great foundation to talk about credibility of witnesses, and the fact that in cross-examination, one of the core duties of the lawyer who is cross-examining you and testing your information is to make sure they diminish your credibility to their benefit. So you've come in, you are the professor of whatever, but if the person is able to whittle away your credibility, it affects the case.
It affects the case. It affects the weight that the judge will put to the evidence that you have given. So sometimes they attack your credibility to show that you have been inconsistent in your evidence. You have in one breath said, yes, I saw a blue sheet, and then in the next piece of evidence you say, oh, the sheet was actually pink. So these are some of the ways in which a lawyer can attack your credibility. And the attacking of credibility goes to the weight that the court will attach to your evidence.
In attacking the credibility, you need to know that you are doing that to achieve something. And you need to know that you are advancing your own case as well.
You are talking about this topic like our target is lawyers who are doing the cross-examination. We need to be in the shoes of the witness. So the witness ought to know that what the lawyer is seeking to do is to weaken your testimony.
Weaken your testimony. The lawyer is on a set agenda to get information from you. Yes, it's not personal. I mean, sometimes
he's doing his job.
We go hard on witnesses. We exit the court.
Some witnesses go hard on us too, especially you're a woman, you're young, she's very elderly or he's very elderly, and he's looking at you like, could be my kid or granddaughter, and doesn't just understand.
Yeah.
So anytime you ask a question, you get a cheeky response. You get like another question back.
And that is one of the things that witnesses must realize. The evidence you are given, you are not given to the lawyer, you are given to the court. And that is why in Ghana, most of the time, you start with my lord or your
My
honor,
lady.
my lord, my lady, because the answer is to the court.
Yes.
You are expecting the court to find or to agree with your version of facts. So you are given an answer to the court. So one of the things that witnesses must also realize is that when you are you appear to be cheeky or defensive, it also
insulting
tells, and
sometimes.
sometimes even insulting.
You start
It-
threatening and all.
Exactly. It also tells on the strength of your case. It also tells on whether the judge would actually believe the information that you're given to the court.
Well, I mean, sometimes also we can't falter the witnesses in the kind of answers they give. We must admit that some are, some may come to the court the first time. Some may also see the court set up and, panic. So
I don't think being saucy is evidence that you are panicked.
Oh, yes. I
I
mean,
mean, if you're panicking, you'd rather be,
no, witnesses do
more
panic
sober.
every now and then. And then also because of the self or subconsciousness that, okay, what I'm about to say, how is the judge going to take it, in the matter of the first place? And then how is my lawyer also going to see me? Is he going to say that I'm not doing well, I'm not, professing the right answers?
I think it's
Or
more
how-
from a place of fear. If you ask me, most people are aggressive when they're afraid of losing something,
Afraid of losing something.
afraid of being disrespected, afraid of being exposed. If not, why should you attack officers of the court?
Sometimes it's a defense mechanism. Sometimes they say attack is the best form of defense. So in order that they defend themselves, they attack. So I think that it's not desirable. As officers of the court, lawyers as officers of the court, you must also attempt to put witnesses at ease.
Yeah.
Whilst you know that you are backing a witness in a corner because you want the witness to agree with your version of facts, you must also do so with some amount of respect for each other.
Okay.
So,
You have spoken to demeanor,
yes.
the substance of the
The substance
testimony.
of the testimony.
You've talked about inconsistencies. What are the other things that lawyers seek to elicit from a client just to diminish their, from a witness to diminish their testimony?
Whether there exists some potential bias, for example. So if you are a relation of a person who is, or you stand to gain some pecuniary benefit from the evidence that is being given, there is a real likelihood of bias. So you are not, the lawyer may attack your credibility based on the
So bias,
existence
interest, or some motive?
of bias,
Or
interest,
whether,
or motive. Yes.
you gain some financial,
Financial
Pecuniary interest
yes,
in the
interest
testimony.
in the testimony.
or
and-
even you've been paid before.
Yeah.
yes,
Probably you've been paid
You've
to
been
appear
paid,
to give
yes.
the testimony.
yes.
And then sometime also, people are only exposed to certain aspects of the fact, yet they come and pose as if they know all it all.
Everything here.
And
Yes.
so I asked
They
you a
get
question about what happened, and you said it happened at 6 a.m. on this junction and all that. Probably that's all you know about it. Thereafter, if it is an accident case, whether the people were taken to hospital,
don't
they
know.
were discharged, you don't know. So they come posing as though they know
They
ex-
actually transported the victims,
the
to the
victims
hospital.
they put themselves in
Yeah.
it and all that. So in that circumstance, a lawyer would obviously discredit your version of the story whilst putting across their own version of the story.
And
There are
that-
two things. It's targeted at your testimony and then also at your personality. With the testimony, it goes to the fact that you saw just a little part of it, but you want to testify as though you know it all. In respect of the personality also, it comes to the biases. How are you related to the person on whose behalf you are testifying? Obviously, there's no way I'm going to testify against any filial, relations, right? And so once the lawyer sees that you are testifying because the person is your husband, because the person is your relative, then they would attack your person. They will seek to, diminish the kind of reputation that you have put before the court. Sometimes, the questions, where do you work, where do you live, it is also to build a reputation for the judge to see the kind of person, your stature, the kind of person you are.
We sampled some people's opinion on the topic. Let's take a listen and react the same. Then we pick up from where we stopped.
Okay.
A witness is someone who was present at an event, or maybe an event was ongoing and then was there and then watched whatever went on. So when he or she is being called to court, he's able to testify that, oh, I was here when this event went on. I think that's what a witness is.
A witness is you being present in an event. So you can be called to give an evidence since you were a witness to that event. So one can be a witness in a marriage and then also be a witness in the courts.
So witnesses serve as referees to a marriage that has taken place. So they are people, they can be friends, they can be relatives who stand in to really ascertain the veracity of a particular marriage. Because if there's a marriage ceremony, there should be people to witness, or there should be people to serve as a reference point that a marriage ceremony has taken place. And that is the basic function of witnesses. Again, when we are talking about witnesses in baby court, there are people who stand in to testify about an occurrence or an act or an event to give more account of something that has already happened. So indirectly, or in a basic, for want of a better word, we can say that they are reporters, eyewitnesses. So they look at the thing, or they are people who have experienced what has gone on or the occurrence, and they feel like they are the proper people to give a good account of the act.
A witness is an individual who has personal knowledge or experience of an incident and can attest to its truth or accuracy. An example can be a court marriage, whereby the couple need a witness. In case of anything, the witness can be like, oh, I was there when the marriage happened. So that's what I know.
Well, that's a very impressive opinion from the public in respect of what a witness or all about witnesses. For a moment, I felt they are law students, or they are exposed to law until I was informed that these are randomly selected people. And I think that the 2013 election petition has also opened up this side of legal practice to the lay people, to the extent that a lot more people are interested in the course. So, I'm not surprised that people are now learning about what happens in court, learning about legal matters and all that.
Yes, I was quite impressed with the answers as well. Very straight to the point. They understood what a witness was. They all mentioned that you must have first-hand information. So it's clear that they understand hearsay evidence is generally inadmissible because you cannot be seen to be rumor mongering. Very excellent answers. I'm very impressed.
Great. So when we're talking about witnesses testifying actively in court, we talked about the fact that in cross-examination or during the process, the judge would take into account the demeanor of the witness. I have seen cases where lawyers intentionally ruffle people's feathers, so they stress the witness to the point that, well, within the law, not, to the point where they flip, and then you see another side of them, and then it's shows that, look,
that usually also happens when you believe that the witness is being economical with the truth. When when the answers are very well rehearsed, and you are cross-examining the person keeps on going from A to B to C. As soon as you start off with letter P, and then they are very confused. So it's one of the strategies that
you're so right.
one of the strategies that lawyers use to attempt to show that the witness is not being entirely truthful.
I have seen a rehearsed witness who was so well rehearsed that any question you asked him, after saying one thing, he goes back to the rehearsal, what he has pre-planned, and he must rehash it. So when you check the record, it's the same thing. So after he says, yes, this happened, but I would say, and then they repeat it. So you just realize it's the same thing over and over again.
And what usually happens is that even when you have asked a question about, and you know the joke about the Agama lizard, when you have asked a question about a tree, they would definitely bring in
the Agama
lizard into the
because that's what they prepared for.
That's what they prepared for. So these are some of the ways that you as a lawyer, they punch holes in your evidence.
And the judge is human. He'll see through this, and then he would see that, look, this witness has a limitation. Probably is being economical with the truth, is massaging the facts, or there's something really going on here.
Yes.
Well, so you see, mostly you get a question, is it okay to prep a witness? Is it okay to tell a witness what to say and all that? For me, I don't think there's anything wrong with prepping a witness to know the witness's case, but obviously not to tell the witness what to say in court.
You want to tamper with the witness and put words in their mouth. To support your case.
So it is very important that before you take a witness to the court for purposes of testifying, the witness would have to know the claims before the court, what it is the witness is testifying about. I mean, sometimes you file a witness statement in 2018 and trial comes up in 2024. Most often than
land
not,
matters especially.
The person might have forgotten about, what the person has placed before the court. So that little time with a witness, right, will help the witness to refresh and then, come to court and testify. But the danger is also that if you don't take care, the witness mounts the witness boss and thinking that the answers would have to be in a certain way. And that brings the fact that a witness at that point can be nervous because they are always conscious about what they are saying. How is my lawyer going to take this? How is the judge going to perceive what I'm saying?
And then in the box, they'll be looking in their lawyer's direction, hoping for some hint or cue.
Or confirmation.
You have to see that they're doing a great job.
Exactly. So because of these facts, and once a lawyer sees that the witness is fidgeting around and all that, then the lawyer jumps on it and then tries to push. So sometimes your demeanor will give you out. And it is not their fault. As I always say, we can't falter them because one, maybe the preparation, creates the impression that the person is to testify in a particular way.
It's very, very important what you say because we all know that, yes, it is your testimony, but you require a lawyer to organize it and file it for you.
Exactly.
So I've seen very nervous witnesses where, yes, this is their story. The lawyer just helped type it out and then got them to read over, confirm, and then they signed. But opposing counsel was poking until this guy just broke and said, well, his lawyer just typed it and asked him to sign.
Well,
He didn't say it wasn't his statement
Okay.
because, the lawyer was trying to attack his credibility and suggest that he didn't know the facts of the matter. And he didn't quite get the trap and he fell in it. Only later for the court to realize that, yes, it was indeed his story, but like every lawyer is required to do, that was what happened. I think there's also the requirement of even how to address the bench. Many people who have never been to court, they actually call lawyers my lord, which is a very pet peeve of mine. It's the judge who used to be addressed my lord. And they come to court and they don't know they have to say, yes, my lord, my lord. So they ask the question, they're like, yes, that's what happened.
Some people
they
even
don't
say,
add,
yes, madam, yes,
yes,
sir.
exactly.
all
So
those
that
types, yeah.
prep is not just about the facts per se. It's about what is expected of you to be able to excel at the job.
Yeah.
How you're supposed to demeanor. You shouldn't keep your phone ringing, come early. Do you require an interpreter or translator? In what language? All of those things. Okay, if there's one, this is what the translator will be doing. This is what you can do. You need to wait. They'll be typing. All the little things to make, life easier. It's time for another break. We'll go for a break, and when we come back, we can look at the issue of privileges.
We've already established that everyone is competent to be a witness. However, certain groups of people cannot be compelled to be witnesses. So that's where it feeds into privileges. A privilege is, or privileged information is information that you have received by virtue of a relationship with a person. So, for example, there's what we call the lawyer-client privilege. The information you have given to your lawyer, that lawyer cannot be called upon to testify against you. The lawyer has that privilege not to testify against you or not to disclose that information that you have given. And that is why it is always said that you must be truthful with your lawyer, knowing full well and being confident that that lawyer is not going to use that information against you. Another privilege is the privilege that a physician or psychiatrist has when he is given mental treatment. Because of the stigma associated with mental treatment, the law provides that the psychiatrist will not disclose that information as a witness. Other forms of privileges include trade secrets. You cannot compel, for example, Coca-Cola to come and give you their full recipe for the Coca-Cola. You can't. State secrets are also privileged information. Informants, when it comes to persons that have committed crimes, when it comes to gang activities, informants, etc., are also protected.
For fear of retribution,
For
they are
fear of
protected.
retribution. They are
from
protected.
testifying in open courts because of the nature of our courts.
Of the nature of our courts, which is open. Other persons include conversations between married couples, whether it's monogamous or polygamous. Those are still privileged information. If they've disclosed that information, knowing full well that it's not going to be disclosed to another person, you cannot compel a wife to testify against a husband. So to keep
your information secret, tell your spouses.
Tell your
That
spouses.
way, the court is not likely to call on them to come and testify.
Testify
in matters that would put you. And then also political votes. Our laws provide that the way you vote, we do a secret ballot.
Yes.
So you are not, you can't be compelled to come and testify as to
At
how you
all.
voted, especially if somebody, you promised to vote for somebody and then
Yes,
the
exactly.
person
Didn't
says
vote for.
you did not,
Yeah.
and they try to bring you to court to
No.
come and prove how you voted. That's, you have privilege there.
When you go to meet your lawyer,
Mhm.
or in certain kind of conversation or certain kind of transactions, you have to feel free and divulge the information that is relevant, to be placed before the court in respect of your case. But we must also know that the privileges are not absolute,
Yeah.
and there are certain exceptions. For example, the conversation between the husband and a wife, conversation between a lawyer and a client, if it pans out that the said information is needed, in a fight of crime, the lawyer or the person who has received the information can be compelled to divulge the information to court. In other instances also, if it is so needed, in the interest of justice or in the combat of crime again, you can be compelled to, give the information that has come to your knowledge. But most importantly, you are protected in respect of your conversation with a lawyer.
Yeah.
That cannot be taken away from
So
you.
in other words, what you're saying is that before you commit the crime,
Hmm.
if you tell
Your
your lawyer that you intend to do
commit
this,
a crime,
you will not be covered
No.
by the law.
yes,
That lawyer, as a matter of ethics, is required to actually report you and can actually testify
in
against
respect
you
of
in
what
respect
you
of
told.
that information
Exactly.
and not
just
the
a
other
crime,
things.
an
you know.
intentional thought as well.
Yeah.
An
So you go
intentional
like, I'm
thought
going
as
to
well.
beat somebody up. Yeah. So that can also, or harm somebody or defame somebody. Those are thoughts. If, on the other hand, you've already committed the crime or offense, and you now run to a lawyer to say, look, this is what I've done, defend me. At that point, the lawyer, there's this privilege available where the lawyer cannot be compelled to testify against you.
And that also feeds into that privilege against self-incrimination,
Yes.
and also the duty of a lawyer to also present the various defenses that are available to you. So that perception that once you have done something that is wrong, a lawyer just jumps up and
To defend
defends
you and
No,
lies his or her
the
way
out.
through it.
It's not true.
Yeah.
What matters is that the lawyer, there are certain defenses that are available to you, and those defenses are explored by a lawyer to attempt to mitigate the wrongdoing or otherwise.
So, but ultimately, the lawyer has to present the options, and it's your call. You,
Yes.
the lawyer, is just your soldier. If you say this is my war strategy, and though I know I'm wrong and I've committed and I'm guilty, I want you to defend me. That's it. But if the lawyer presents it and you go like, well, I want to concede that I indeed did and plead guilty, that's a different path.
Of course.
We have some questions from our viewers.
Very well.
Let's look through and attempt to resolve them.
I was at a bus stop when a fight broke out between two men. In the end, one was badly injured, and being a good Samaritan, I assisted in taking him to the nearest health facility after we successfully stopped the fight. Just yesterday, he showed up at my home, pleading with me to testify for him in court because he made a police report and the matter is now in court. I told him I had no time to be in court as my job was demanding. I also do not want to be connected to their case in any further way. Can I be compelled to testify? What are my options to stay away?
The position of the law is that even though the person is competent to testify because this person is an eyewitness and the person has a personal knowledge in respect of the matter at hand. However, the person cannot be compelled to testify in court. So it is up to the this person who wants the eyewitness to testify in court to choose the available options. One, you either apply to the court for the court to subpoena the witness to come and testify in court, because, I mean, you tried to get the person to testify in his or her own volition, but the person rejected that call. So the option available to you is to get the court to subpoena the witness. But of course, you are making the application to the court for the person to be subpoenaed. The danger is that, as the person states, he or she is trying to stay away from the matter and all that. So sometimes, yes, the court has subpoenaed me. I have no option. I have to go. The person comes and is unwilling. Exactly, is unwilling to give you that kind of testimony that you want.
And then he says, "I don't remember," to every question that is asked.
Exactly.
That would be a tragedy.
Of course, it's a big tragedy.
But to fix the first part about being busy, I think a subpoena will fix that, right?
Yes, the subpoena will affect it. If you are busy, once you have received court summons, you are duty bound as a citizen of Ghana to follow that that order. Otherwise, there are implications. So you can get in there. Whilst the witness may say, "I don't remember," the witness is also bound by the duty to understand that if you say you don't remember when you actually do remember, it means you are not telling the truth to a court.
Who is going to prove this? Who is going to walk in my mind?
Well, in whatever way possible, if it is found out.
But can't we also say that the person does not appreciate the fact that he or she has to tell the truth in court? And which is a point to disqualify a witness from testifying. So I think it's a thin line, not willing to testify and you going under subpoena and give unfavorable answers.
But this happens a lot in criminal matters. You would have witnesses just disappear, compromised. I mean, it could be anything because you don't control your witnesses.
That's why in recent times there's been the Witness Protection Act, there's the Whistleblowers Act, which have provided mechanisms and means that protect witnesses, especially when they are in fear for their lives.
Yeah. Because we don't know who the other party is, and probably that is why he doesn't want to be part of it.
And sometimes because of how acrimonious the system is, for us lawyers, we appreciate the fact that we are putting across our case.
We're just
you are my mate in school,
courts.
she's my mate in school, the person is my mate in school and all that. So beyond the courtroom, we meet out of the court.
Beyond that case,
exactly.
This life, really.
But the parties or the witnesses do not see beyond that. And sometimes some parties or some witnesses do not even want your lawyer, to converse with the other lawyer.
Yeah.
So because of how acrimonious the system is, and then because of the fact that in criminal matters, you don't
There's somebody's
know
liberty that is at stake.
Exactly. So are you ready to take the blame that, because of your testimony, somebody is languishing in jail?
Who have gotten into the emotions. I mean, where they are doing a matter against you and they've taken it personal. They are not the parties.
They're not parties.
They are not parties to it. They know that the two of you are just trying to earn a living and help society to the best of your ability, but you come in, you greet, they don't want to hear you, they don't want to see you.
Well, there's no crime against.
I mean, you can't compel them to be civil, but
it is important to look beyond that particular case. And this is part of the reason why even court-connected ADR has come in to attempt to settle matters and mitigate this unnecessary acrimony when it comes to disputes.
But from experience, you find that the cases that start out mostly as acrimonious, they end up being settled.
Yes.
As
That's
against those that are just normal, everybody's calm about it.
Well, I think time always heals.
Yeah.
You
Time
can't always eat your cake and have it, and sometimes also you cannot insist of your pound of the flesh. You should be prepared to, give away something.
It should be like the other woman in the Solomon story who said, "Leave the baby alone and don't cut it as well."
So you should be willing to,
Great.
let go of something
Great.
to achieve something.
Who would have thought a discussion on witnesses would be this exciting and engaging? Today, my co-panelists have been Iris K. Agui-Olins and Tony Nyako. My name is Noella Seidu, and this has been our show.